Across the United States, traffic laws change quietly every year. Adjustments are introduced through state legislatures, regulatory agencies, and transportation departments. Most of these changes go unnoticed until drivers receive a citation, renewal notice, or updated handbook. But in February 2026, several confirmed driving law changes are drawing particular attention, especially among older drivers. Some of these updates involve licensing requirements, renewal procedures, insurance standards, and vehicle compliance rules that could carry financial penalties if misunderstood. But here's the question. Are these new rules simply modern safety updates, or could they disproportionately impact senior drivers who may not be fully aware of the changes? Let me know your answer in the comments below. To understand the scope of the February 2026 driving law updates, it is important to clarify that traffic regulations in the United States are primarily governed at the state level, while federal agencies, such as the National Highway Traffic Safety Administration, set nationwide safety standards. Individual states retain authority over licensing requirements, testing procedures, and enforcement policies. According to official state legislative records published in late 2025, multiple states passed amendments affecting driver's license renewal cycles and medical certification requirements. These laws were debated publicly, approved through standard legislative processes, and signed by governors before their effective dates in early 2026. One category of changes involves in-person renewal requirements for certain age groups. Several states adjusted renewal intervals for drivers over specific age thresholds, citing updated road safety data and accident reporting statistics. According to publicly available transportation safety reports, lawmakers referenced studies showing higher rates of certain types of collisions involving aging drivers, particularly in low-visibility conditions and complex intersections. It is important to note that the majority of senior drivers maintain safe driving records. Federal traffic safety data consistently shows that older drivers often drive fewer miles annually compared to younger age groups. However, policymakers in some states concluded that more frequent vision screening or in-person renewals may improve overall roadway safety. In practical terms, this means that in some jurisdictions beginning February 2026, drivers above a certain age must renew licenses more frequently or complete updated vision assessments. Failure to comply may result in license suspension or fines, depending on state law. Another confirmed change involves stricter enforcement of expired registration penalties. Several state motor vehicle departments updated fine structures to reflect inflation adjustments. According to official DMV publications, these adjustments were part of broader budgetary reforms rather than age-targeted measures. However, because some older drivers maintain vehicles for longer periods and may drive less frequently, critics argue that they could be more vulnerable to oversight-related penalties. Insurance compliance requirements also saw updates in certain states. Legislatures approved modifications to minimum liability coverage amounts effective in early 2026. Departments of insurance publicly stated that these changes aim to reflect modern repair costs and medical expense realities. Drivers who fail to meet updated minimum coverage thresholds may face citations, registration suspension, or reinstatement fees. Importantly, none of these changes were enacted through emergency executive orders. They followed standard legislative procedures, including committee hearings, fiscal analysis, and recorded votes. Public transcripts show that debates centered on safety data, actuarial projections, and fiscal sustainability. Some advocacy groups representing senior citizens raised concerns during legislative hearings. According to meeting minutes and public testimony records, representatives argued that additional renewal requirements could create logistical challenges for elderly residents in rural areas where DMV offices are limited. Lawmakers responded by referencing mobile renewal units and online scheduling expansions designed to mitigate access concerns. Another area of reform involves distracted driving enforcement. Several states strengthened hands-free laws, increasing fines for repeat violations beginning February 2026. These statutes apply universally across age groups, but legal analysts note that public awareness campaigns often target younger drivers. Senior drivers unfamiliar with newer in-vehicle technology systems may also need to review updated compliance standards. One interpretation of these February 2026 changes is that they reflect modernization rather than restriction. Another perspective raised in policy discussions is that regulatory complexity can unintentionally create compliance gaps, especially for individuals who rely on traditional renewal habits formed decades earlier. Turning to the legal framework, driver licensing operates under states' police powers. authority reserved to states to regulate health, safety, and welfare. Courts have consistently upheld reasonable licensing requirements, so long as they do not violate constitutional protections such as equal protection or due process. In previous cases, courts have ruled that age-based renewal intervals are constitutionally permissible if supported by rational safety justifications. Legal precedent generally grants states broad discretion in traffic safety regulation. However, discriminatory enforcement or arbitrary administrative practices could face judicial scrutiny. This analysis is provided for informational purposes only and does not constitute legal advice. A key turning point in the February 2026 updates came when certain states adopted electronic medical reporting systems. Under these systems, physicians may submit reports if they believe a patient's medical condition affects driving safety. While such programs are not new, expansion of digital reporting has raised questions about privacy and due process protections. Transportation departments have publicly clarified that medical reports do not automatically result in license revocation. Instead, they may trigger evaluation procedures, additional testing, or temporary restrictions. Administrative appeal rights remain available under state law. Still, advocacy groups caution that awareness gaps could leave some drivers unprepared for new compliance expectations. Financial penalties associated with non-compliance vary by state. According to updated DMV schedules published in January 2026, fines for expired license renewal can range from modest late fees to higher penalties if driving privileges lapse entirely. In some jurisdictions, reinstatement may require additional testing. Another confirmed change involves updated road test scoring metrics in select states. Transportation agencies stated that revisions align with current traffic patterns and emerging vehicle technologies such as advanced driver assistance systems. These adjustments apply broadly, though older drivers retesting after lapse periods may encounter unfamiliar evaluation criteria. Public reaction to these updates has been mixed. Some citizens view them as overdue safety enhancements aligned with evolving road conditions. Others see them as administrative burdens that may disproportionately affect seniors on fixed incomes. Legal scholars emphasize that the constitutionality of such measures typically hinges on rational basis review. Unless a law discriminates against a protected class or infringes on a fundamental right, courts generally defer to legislative judgment in matters of public safety. Driving itself has been consistently recognized by courts as a regulated privilege rather than an absolute constitutional right. However, procedural due process protections apply when states suspend or revoke licenses. Notice and opportunity to contest administrative actions remain essential safeguards. In the coming months, monitoring how these February 2026 rules are implemented will be critical. Enforcement discretion, public outreach efforts, and administrative flexibility may determine whether compliance rates remain stable or citation rates increase. What makes this situation particularly significant is not a single sweeping federal mandate, but a pattern of state-level adjustments occurring simultaneously across multiple jurisdictions. The cumulative effect may feel substantial, especially for drivers accustomed to long-standing renewal routines. As with many regulatory updates, awareness becomes the most powerful tool. Official DMV websites, state legislative portals, and public notices provide updated compliance information. Drivers are encouraged to review their specific state's effective dates and requirements. In the next portion of this analysis, we will examine state-by-state implementation patterns, discuss potential legal challenges that could arise, explore how courts evaluate equal protection claims related to age-based renewal laws, and analyze whether any of these February 2026 changes may face judicial review. Given the confirmed updates and their potential financial implications, do you believe these reforms represent necessary modernization, or do they risk placing unintended burdens on senior drivers? Share your thoughts in the comments, and stay with us as we continue this in-depth legal breakdown grounded in official records and established precedent. As we continue examining the February 2026 driving law changes, it becomes important to look at how different states are implementing these updates in practical terms. While the legislative themes are similar, renewal adjustments, insurance minimum increases, compliance enforcement, the application varies significantly depending on jurisdiction. According to publicly available state transportation bulletins issued in late 2025 and early 2026, some states have adopted tiered renewal systems. Under these systems, drivers above a certain age threshold must renew licenses in person rather than online. Transportation departments have stated that the purpose is to ensure updated vision screening and identity verification. In official statements, agencies emphasized that these measures are preventative rather than punitive. However, administrative law experts note that implementation matters just as much as legislative intent. If appointment systems become backlogged or rural access remains limited, compliance challenges may increase. According to department press releases, some states expanded mobile DMV units and community outreach scheduling in response to these concerns. Whether those measures sufficiently address access disparities will likely be evaluated over time. Another dimension involves equal protection analysis under the 14th Amendment. Age-based classifications in licensing laws are typically reviewed under rational basis scrutiny. Courts generally uphold such classifications if they are reasonably related to a legitimate government interest, such as roadway safety. Previous court decisions have affirmed that more frequent testing for older drivers does not automatically constitute unconstitutional discrimination, provided it is supported by safety data and applied consistently. One interpretation of the February 2026 reforms is that lawmakers relied on updated actuarial and traffic safety statistics to justify targeted adjustments. Another perspective raised in policy discussions is that aggregate statistics may not reflect individual capability, meaning broad age thresholds can appear over-inclusive. If legal challenges arise, courts would likely examine legislative records, committee reports, and statistical evidence presented during debate. Judges would assess whether the law serves a legitimate public interest and whether the means chosen are rationally related to that objective. Historically, this standard has been deferential to state legislatures in traffic safety matters. Insurance minimum increases also warrant closer examination. According to official insurance department summaries, rising vehicle repair costs, medical expenses, and liability settlements influenced updated coverage thresholds. These adjustments are not age-specific, but they may affect fixed-income drivers more acutely. Failure to maintain minimum coverage can result in registration suspension, fines, or reinstatement fees. Administrative due process protections typically require notice before such penalties are finalized. From a constitutional standpoint, courts have consistently held that states may condition driving privileges on compliance with insurance mandates. Challenges tend to focus not on the requirement itself, but on whether enforcement procedures provide adequate notice and opportunity to contest administrative errors. The expansion of electronic medical reporting systems adds another layer to the regulatory framework. According to state health and transportation agencies, physicians may report medical conditions that could impair safe driving. These reports generally initiate review rather than automatic revocation. Drivers are usually notified and provided an opportunity to submit additional medical documentation or undergo testing. Privacy advocates have noted that medical reporting systems must comply with federal and state privacy laws. Transportation departments have clarified that reports are handled within regulatory frameworks and limited to driving fitness determinations. Legal precedent supports such programs when procedural safeguards are in place. Another confirmed February 2026 update involves enhanced enforcement of distracted driving laws. Several states increased fines for repeat hands-free violations and clarified definitions of prohibited device use. Law enforcement agencies publicly stated that education campaigns would accompany enforcement efforts. Because technology use varies across age groups, awareness outreach will likely influence citation patterns. A significant turning point in the broader conversation occurred during legislative debates when some lawmakers proposed mandatory road retesting for drivers above certain ages. In several states, those proposals were modified or rejected in favor of vision-only screening requirements. Committee transcripts show that lawmakers weighed concerns about fairness, resource allocation, and empirical safety data before finalizing language. The final statutes adopted in February 2026 reflect compromise rather than sweeping overhaul. Most provisions adjust frequency or documentation requirements rather than imposing categorical restrictions. Still, perception plays a powerful role in public response. For many drivers, especially seniors who have maintained clean records for decades, additional administrative requirements can feel like an implicit questioning of competence. Policymakers have attempted to frame the changes as universal modernization rather than targeted limitation. Courts reviewing potential disputes will likely focus on process rather than perception. If administrative agencies provide clear notice, reasonable access to compliance mechanisms, and appeal rights, judicial intervention may be limited. It is important to emphasize that this discussion is for informational purposes only and not legal advice. Individual compliance obligations depend on state-specific statutes and regulatory guidance. Looking forward, enforcement data over the next year will likely shape whether additional reforms are proposed. If citation rates increase disproportionately among certain demographics, advocacy groups may request legislative review. If compliance remains stable and accident data improves, lawmakers may view the reforms as validated. Historically, traffic regulation evolves incrementally. Seatbelt mandates, emissions testing, graduated licensing systems, and hands-free requirements all faced initial resistance before becoming normalized components of roadway safety policy. The February 2026 changes may ultimately follow a similar trajectory. What remains central is transparency. Clear communication from transportation departments, accessible renewal systems, and straightforward penalty schedules reduce confusion. Drivers who proactively review official DMV announcements are less likely to encounter unexpected fines. From a broader constitutional perspective, these updates illustrate how states exercise police powers within defined legal boundaries. Driving privileges remain regulated activities subject to administrative conditions. However, procedural safeguards ensure that enforcement actions are reviewable and contestable. As courts, agencies, and citizens navigate these adjustments, balance remains the guiding principle, balancing mobility and independence with collective safety and fiscal sustainability. So where does this leave senior drivers? It leaves them in largely the same constitutional position as before, protected by due process, subject to regulatory compliance, and empowered to challenge administrative decisions if necessary. What has changed is not the fundamental legal framework, but the specific administrative requirements within it. And that brings us back to the broader issue raised at the beginning of this analysis. Are the February 2026 driving law changes a necessary response to evolving safety data and economic realities, or do they risk creating unintended burdens for older drivers who rely on consistent mobility? Given the confirmed statutes, official agency statements, and established constitutional precedent, do you believe these reforms strike the right balance between safety and fairness, or should lawmakers revisit certain provisions? Share your perspective in the comments below. If you found this investigative legal breakdown helpful, subscribe for more in-depth analysis of traffic law changes, constitutional issues, and the real-world impact of new regulations.